So I wanted to pose a question, which is, does the legislature enact invalid statutes? As much as it pains me, I would expect your answer, unfortunately, to be yes. Now, whether good or bad, depending on your perspective, the California legislature does, in fact, enact statutes that the judicial branch of government at either the state or federal levels later determines to be invalid or unconstitutional. The most recent example is Assembly Bill 51 from 4 years ago in 2019 that was struck down first by a federal district court shortly after its enactment. And that ruling was recently upheld by a three-judge panel of the Ninth Circuit Court of Appeal. And so as a result, AB 51's ban on requiring mandatory arbitration agreements as a condition of employment was invalidated. And the federal courts all found that AB 51 violates federal law. There are several other examples I've come across recently where state courts have struck down enacted bills that, for example, attempted to amend the Political Reform Act, Prop 103 dealing with insurance rate regulation, and a handful of other voter-approved ballot measures. For example, in the case of Howard Jarvis Taxpayers Association versus Newsom, which was a legislative attempt to overturn a ban on public financing of campaigns by statute, was found to have violated Prop 73 adopted by the voters. There's the AmWest case that said an exemption of surety companies from the scope of Prop 103 and its rate regulation didn't further that act's purposes and was therefore invalid. There was also a appellate court decision with review denied by the California Supreme Court, another effort to create what's called a portable persistency discount in Prop 103 insurance rate regulation. FTCR versus Garamendi said that that legislative amendment, despite a 2/3 vote of both houses and signature by the governor, didn't further the purposes of Prop 103 and was therefore invalid. The Garner appellate court decision ruled that a legislative amendment of Prop 36 was inconsistent with the terms of the initiative and was therefore invalid. There's some other bases for successful legal challenges of enacted bills, such as vagueness. The California courts have basically described vagueness as nearly unintelligible, which seems surprising considering how much vetting some bill language actually gets in the legislative process here in California. And there's some other bases for striking down statutes enacted by the legislature in violation of the state or federal equal protection clause, an improper delegation of legislative authority, the state's single subject rule. There have also been successful judicial challenges in federal and state courts for legislatively enacted statutes violating state or federal freedom of speech provisions, the ex post facto law, impairment of contracts, the federal supremacy clause, due process, preemption, etc. And I only bring this to folks' attention because if you're operating in the legislative process in the public policy arena, whether you're drafting legislation or you're advocating for or against bills, you should keep in mind some of these bases that have been used to successfully challenge in litigation statutory enactments by the California legislature, and of course, generally try to avoid pursuing actually legislation that might face invalidation by state or federal courts.